Welcome to the third of our video introductions to zones of maritime jurisdiction. So in previous recordings we've covered a number of basic concepts and zones of territorial sovereignty. Then we moved on to look at zones of sovereign rights, the contiguous and exclusive economic zones. And now we'll come to one of my favourite topics in the law of the sea, the high seas regime. So we'll look at some introductory concepts and the freedom of the high seas, and then we'll look at the principle of the exclusive jurisdiction of the flag state and the problem of flags of convenience and exceptions to that exclusive jurisdiction. So let's make a start. In this recording we'll cover the principle of freedom of the high seas, the principle of exclusive jurisdiction of a flag state on the high seas, the flags of convenience problem, exceptions to the exclusive jurisdiction of the flag state, and the geographic extent of the high seas. Let's start with that last point first. What is the geographic extent of the high seas? Article 86 of the UN Convention on the Law of the Sea tells us the high seas are all waters outside the exclusive economic zone, the territorial sea, or the internal waters of any state. Although it's not quite that simple. So the first thing we should note is that the seabed under the high seas is not part of the high seas regime itself necessarily. Some seabed areas outside the exclusive economic zone may form part of a coastal state's continental shelf, and therefore the coastal state will have jurisdiction over those areas, or at least potentially it will, and those are shaded in orange in this map. Further, the area in beyond national jurisdiction, or simply the area with a capital A, is administered by the International Seabed Authority, at least as among parties to the Law of the Sea Convention. Those provisions regarding the International Seabed Authority are obviously not binding on non-parties, such as the United States of America. So that's the first point to note. The second point to note is that actually the law of the high seas still applies in the EEZ to the extent that it is not incompatible with the rights of the coastal state in that zone. So for some purposes the high seas still constitute all waters outside any coastal state's territorial sea, and that rule giving the high seas some application in the territorial sea is found in Article 58.2 of the UN Convention on the Law of the Sea. So let's consider now the principal freedom of the high seas, or the principal freedoms, I should say. So when we talk about the freedom of the high seas, we mean a number of things. The first is freedom of navigation. All states are entitled to have vessels bear their flag, and those vessels are then entitled to freely navigate on the high seas, that is, to navigate without interference from other governments or navies. Second, the freedom of the high seas is the freedom to carry out certain activities. And the freedoms listed in Article 87 of the UN Convention on the Law of the Sea include, but are not limited to, freedom of navigation, freedom of overflight by aircraft, the freedom to lay submarine cables and pipelines. Submarine cables are obviously extraordinarily important to internet communication and telephone communication. The freedom to construct artificial islands and other installations, at least beyond national jurisdiction and the limits of other states' continental shelves. Freedom of fishing, historically an exceptionally important freedom, and freedom to conduct scientific research. So, all of those freedoms are exercised under the principle of the exclusive jurisdiction of the flag state. Now let's explore that principle and some of the problems it potentially gives rise to. So the first point is that the flag state, being that state which has granted a ship the right to fly its flag, has exclusive jurisdiction over that vessel while it is on the high seas. So as I've said, the fundamental point here is that that is an immunity from interference by other ships, and it means that the events occurring on board that ship are regulated by the flag state's law. And it's important to note here that any state can be a flag state, even a landlocked country. which can lead to the ironic situation that a ship might have painted on its bow its home port, and that home port might actually be a landlocked city. Okay. Now, in Article 92.1 of the Law of the Sea Convention, that principle is expressed in the following language: ships shall sail under the flag of one state only, and save in exceptional cases expressly provided for in international treaties or in this convention, shall be subject to its exclusive jurisdiction on the high seas. So that sets out the idea that ships are only entitled to one flag and one set of papers. So a ship using two or more sets of national registration at its convenience can be treated as a stateless vessel under Article 92 of the UN Convention on the Law of the Sea. And a vessel that is without nationality is without the protection of being subject to the exclusive jurisdiction of a flag state, which means any other state's government vessels could potentially board it, inspect it, or otherwise interfere with it. So what does exclusive flag state jurisdiction mean in practice? Well, for example, the flag state will have jurisdiction over the crew, even if they're foreigners. So everything that occurs on board the vessel is subject to flag state law. And it also means that, as I've said, the flag state can enforce its law aboard the vessel, but the flag state is beyond that responsible for seeing that the vessel complies with certain international obligations. Now, that application of flag state law to a vessel does not mean, as we've seen in previous videos, that ships are treated as some sort of floating island or as a territory belonging to the flag state. Obviously, once they pass into coastal state waters or into port, they become subject to the jurisdiction of a coastal state. So they're not a complete territory. However, everyone and everything on board the ship will be treated as one jurisdictional entity linked to the flag state. So it's the flag state that has the exclusive ability to determine the legal consequences of what occurs on board that vessel, unless there's another applicable rule of international law or some kind of treaty agreement, as we'll see. Now, the responsibilities of the flag state in particular include responsibility for the construction, equipment and seaworthiness of ships, and that those comply with certain international minimum standards, with ship manning, labour conditions and crew training, again in light of international standards, and the flag state has exclusive responsibility as regards questions of signals, communication and the prevention of collisions. So all of these are things where the flag state is expected to take responsibility. Now, provisions of the UN Convention on the Law of the Sea here refer to standards set by a competent international organisation. In almost every case, those standards are going to be set by the International Maritime Organization. So the IMO has concluded a number of incredibly important treaties that are subscribed to by virtually all flag states and by the vast proportion of the world fleet when considered by tonnage. And here we have a photo of the International Maritime Organization headquarters in London. So it's concluded treaties such as the International Convention for the Safety of Life at Sea, dealing with matters of safety on vessels, the Convention on the International Regulations for Prevention of Collision at Sea, sometimes known as the Collision Regulations or COLREG, and the International Convention on Standards of Training, Certification and Watchkeeping for Seafarers. So that includes standards dealing with such matters as adequate levels of crewing to ensure safety. So having enough crew to keep a proper watch for hazards. And the International Maritime Organization, which is an organization that achieves a great deal with a very limited budget, has this particular focus on mariners and seafarers, which is symbolized by the fact that it has outside its headquarters this statue of a seafarer at the front of a commercial ship. Alright, let's turn to this question of flags of convenience. Now, there's no agreed definition of flags of convenience, but it essentially refers to a state which will allow a ship which has little or no connection with it to register under its flag. So on payment of a fee, you can become registered to this country's shipping register. And occasionally you'll find internet websites that purport to be able to get you a flag of convenience on payment of a very nominal fee. Now, what's the attraction of registering your vessel under a so-called flag of convenience? Well, it may allow shipping owners to evade taxation and labour and crewing standards that would apply either in their state of nationality if they're a person or their state of incorporation if they're a company. So it may allow, to some extent, a race to the bottom on standards as regards those matters. Also, the flag of convenience itself, as a state or government, may have little interest in, incentive to, or ability to enforce international standards on safety, labour conditions, pollution and fisheries regulations. And indeed, a flag of convenience might be sought out because it's not party to some or all of the relevant treaties on those topics. This is particularly common in the case of unregulated deep-sea fishing. Flags will be sought out that are not parties to relevant treaties, for example, treaties that include provisions on fisheries inspection at sea. The ability of other states to interfere with foreign vessels on the high seas, even those registered to a flag of convenience, is very limited. So a flag of convenience lends the shield of exclusive flag state jurisdiction to these vessels, irrespective of the acts they're engaged in. Although, as we will see, there are some exceptions to that. So let's come to the exceptions to the exclusive jurisdiction of the flag state. We essentially have three categories here: hot pursuit, the right of visit under general international law, and other treaty arrangements. Let's deal with those in turn. First, hot pursuit. The basic idea of hot pursuit is straightforward. The doctrine of hot pursuit allows a vessel which has committed an offence within the jurisdiction of the coastal state to be pursued onto the high seas and arrested there, so long as certain conditions are met. So, if the vessel has infringed coastal state law within internal waters, or within the territorial sea, or the contiguous zone, or the exclusive economic zone, or even a safety zone around a fixed platform in the EEZ, then law enforcement vessels can pursue it out onto the high seas to make the arrest if it flees. However, the conditions involved can be complex and technical. I won't go through all of these in great detail, I'll just flag them. But if you look at Article 111 of the UN Convention on the Law of the Sea, it identifies a number of requirements before one can say that you have a valid hot pursuit. So first, a hot pursuit can only be conducted by a ship or aircraft marked and identifiable as being on government service. So it has to be a military ship or aircraft, or for example, marked Coast Guard vessels. Second, the coastal state must have good reason to believe that the foreign vessel has violated the laws or regulations of the coastal state in the zone under its jurisdiction. So it has to have some kind of reasonable belief or prima facie case. Most importantly, the pursuit has to commence while the vessel is still within one of the coastal state's maritime zones. And in one famous hot pursuit case that was ultimately in part litigated before the International Tribunal for the Law of the Sea, the Volga case involving Australia and Russia, it actually turned out after the fact that the Australian hot pursuit had commenced just outside Australia's EEZ through a miscalculation of the curvature of the Earth's surface. So that sounds straightforward but can actually be quite technical. Pursuit may only be commenced after a visual or auditory signal to stop has been given at an appropriate distance. Now, this rule was actually drafted originally in the 1950s when there was still some doubt about the reliability or validity of giving such signals by radio communication, but that is now a much more common practice. Fifthly, the pursuit has to be continuous. It cannot be interrupted. You need to maintain visual contact with the vessel being pursued, but the pursuit can be transferred between vessels. A pursuing vessel can be relieved. And finally, the right of hot pursuit ends as soon as the pursued vessel enters the territorial sea of another state. Now, there are a couple of points to note here. And One that I want to draw attention to is the idea of constructive presence, which we've discussed to some extent in relation to the contiguous zone. So this is the idea that you can have a mothership that sends out small boats, or where small boats come out from coastal state jurisdiction to interact as a team with a mothership. And in that case, the mothership is deemed to be within coastal state jurisdiction, and hot pursuit can be commenced against it so long as one of the small boats working in a team with it remains within coastal state jurisdiction. This is called the theory of extended constructive presence. I've also flagged up already this idea that there might be a limit on the nature of valid signals to stop, and there's a question mark about whether radio signals are allowed or whether state practice has evolved to encompass that. And very importantly, though we don't have time to explore it in great detail here, only reasonable and necessary force may be used to arrest a ship. So let's pass from hot pursuit on to the right of visit. Now, the first point I'd like to note is that in wartime, a belligerent state may have certain rights to interfere with foreign shipping, which is being used to support the enemy war effort. But outside of armed conflict, the power of any state to interfere with foreign shipping on the high seas is limited. And that limited right of interference in certain exceptional cases where a state's government vessels are justified in interfering on the high seas with foreign shipping, that can be referred to as the right of visit. So the right of visit encompasses a number of occasions when, as we have pictured here, a state's military forces might be justified in inspecting and taking other action against a foreign vessel on the high seas. Here, a vessel suspected of Somali piracy. And while I've just said military forces, obviously law enforcement officials might also exercise the right of visit. So Article 110 of the UN Convention on the Law of the Sea lists cases where a state may exercise this right of visit, and it can be exercised on the high seas over foreign vessels where there is suspicion they are engaged in piracy, the slave trade, and unauthorized high seas broadcasting. And those are the core examples. Absent that, there are very few cases where such a right of visit could be exercised. It does extend also to two other cases where a vessel is suspected of being without nationality, so a stateless vessel, one that is not registered anywhere and has no right to fly a flag, or has two sets of documentation and is using them at its convenience. The other possibility is where, despite the fact the vessel encountered is flying a foreign flag or refusing to show its flag, there is a suspicion that it is in fact of the same nationality as the intercepting warship. And that could be called a right of presumptive flag state authority. States have authority to prevent their flag being abused in such cases. Now, there are limits on the right of visit, and if it's improperly exercised, the vessel has to be compensated. So it's exercised, as it were, at the risk of the intervening state. And it is limited to the cases we've just discussed unless some other treaty gives you a right. So what other treaties are there? Well, there are quite a lot of them, but they break down essentially into a number of categories. So there are specific bilateral and multilateral treaties dealing with, for example, drug smuggling in the Caribbean. There are both bilateral and multilateral treaties in that region, and there are treaties dealing with the interception of narcotic drugs in other areas of the world. Fisheries inspection, various regional fisheries management organizations that attempt to conserve fish on the high seas and manage their exploitation, have provisions dealing with at-sea inspection of fishing vessels, which obviously could involve them being boarded by a vessel of another contracting party to that arrangement. There are some examples of treaties dealing with the smuggling of migrants, moving people across international borders without proper documentation, and there have been arrangements entered, particularly by the United States, dealing with the proliferation of weapons of mass destruction by sea, though there is also a multilateral protocol on that issue. And if you're interested particularly in that last category of weapons proliferation, there is another video in this series dealing with weapons proliferation by sea. But that is our brief tour of the high seas regime, which concludes our brief tour of zones of maritime jurisdiction. So thank you for your attention, and I hope you have found these recordings interesting and useful.